I study rap battles for a living.
In this corner, the culture. In the other, the law. And in the middle of the ring, two words that can flip a career: defamation and context. Tonight we're running the tape on how a courtroom tried to score a rap battle, bar for bar, law for law. Buckle up, champ. Picture this. June 30, 2025, Manhattan Federal Court. Judge Jeanette Vargas is asking out loud, who is the ordinary listener? Is it a hip-hop head catching every layered jab, or someone hearing a viral hook at a birthday party? That's not a skit. That's real dialogue from the first big hearing in Drake versus UMG over Kendrick Lamar's Not Like Us. As AP reported, it was a hearing where the raw creativity of hip-hop brushed up against the staid confines of federal court. The question on the table is the oldest one in rap beef history dressed in a suit. Are these bars facts or just trash talk? New York has a test for that, the Steinhilber factors, a checklist judges use to tell opinion from fact, precision of the words, whether they can be proven true or false, the vibe and setting, the whole package. It's nerdy, but it's the exact framework courts use when lyrics walk into a courthouse. Drake's side opens with a simple play. If a reasonable listener could take some of those lines as stating a specific harmful fact, you can't bench the case this early. Let it go to discovery. Let us prove it. UMG, meanwhile, leans into culture. Rap battles run on exaggeration. Jokes, jabs, and haymakers aren't affidavits. The label argues Not Like Us lives in a world of spectacle and swagger, not sworn statements. The legal word for that is rhetorical hyperbole. Yes, it's a thing. As UMG's attorney Roland Ransom put it to the judge, context is key, before he apologized for the profanity he had to recite while quoting Drake's lyrics from Made Freestyle, which he aimed at Kendrick Lamar. And the judge? She's not pretending this is easy. She keeps returning to that ordinary listener idea like a chorus, because Not Like Us wasn't just a diss song, you heard it everywhere. Playgrounds, gyms, grocery stores, sandwiched between salsa and toothpaste. The moment a diss track explodes beyond the core audience, the ordinary listener might not know a double entendre from a double time flow, and that matters when you're grading lines for harm. Meanwhile, the lawsuit itself kept evolving as the culture did. Drake amended it on April 17, 2025, after the Super Bowl and the Grammys, arguing those megastages introduced millions of brand new ears to the accusations, turning a rap beef into a mass-market character hit. Reuters captured that update bluntly. Drake says UMG tried to profit by making him a pariah, while UMG called the whole thing baseless and an affront to creative expression. That's not rap talk. That's legal sworn-up language. And offstage, there were real-world scares. A security guard was shot outside Drake's home in Toronto in May 2024. Toronto police briefed the press on camera. Nobody in court tied that event to a lyric, but when you're arguing harm, headlines like that sit heavy in a judge's nine. So what is this case really? It's not just Aubrey versus UMG. It's hip-hop versus the rulebook. If a court says a diss bar can be taken as a factual claim in certain contexts, every future diss suddenly has to wear reading glasses and a legal disclaimer. If a court says it's all just performance, then the nastiest punchlines get a much wider shield. Steinhilber isn't a mixtape title. It's the guardrail for what rappers can safely say without dragging a label into the witness box. Quick corner talk before we swing to round two. Tap like, smash subscribe, and ring the bell. Think of it as touching gloves with the algorithm. It's free, it's fast, and it tells YouTube you want more receipts than the stadium tour merch table. Now, gloves back up. To understand why that I study rap battles for a living line matters here,
I study rap battles for a living.
rewind Drake's own playbook. He said it years later on LeBron James and Maverick Carter's HBO series The Shop. But back in March 2009, just weeks after So Far Gone, Drake lined up a posse cut called Good Riddance Aristo Diss, Toronto lineup and all, to box out a local rival named Aristo. The title said it out loud. Features stamped it in bold. Bars went straight at his opponent, down to a Bramalea jab that still gets pulled up in comment wars. That's Drake, not a blog.
As Rolling Stone Australia put it, Drake loves rap battles so much, I guess it's as long as he's the one winning.
Roland Ransom put it in court. What you hear in these rap battles is trash talking in the extreme, and it is not and should not be treated as statements of fact. The point isn't to relitigate old lyrics. It's to show the court that the stage has never just been the stage. The studio bleeds into the street. The booth bleeds into the press conference. When judges ask about ordinary listeners, they're really asking, what happens when insider barbs become neighborhood anthems? And just when you think this is merely about metaphors, a new player stepped into the light with an eyebrow-raising letter. Sir Lucian Grainge, UMG's boss, told the court he has invested hundreds of millions of dollars in Drake, and this part made headlines, confirmed the purchase and ownership of the bulk of his recording catalog and the purchase of his music publishing rights, filed August 15, 2025. Translation: the label owns most of Drake, front and back. That one sentence could reshape the power dynamics of the entire fight. UMG argues against adding Grainge as a document custodian, arguing Drake already got 11 key custodians, including the label head who actually oversaw the drop. In a sworn statement, Grainge says he didn't see the cover art, the video, or hear Not Like Us until after release. UMG's filing: Drake lost a rap battle that he provoked in which he willingly participated. Instead of accepting the loss like the unbothered rap artist he often claims to be, he has sued his own record label in a misguided attempt to salve his wounds. UMG claims that while Not Like Us features hyperbolic insults, Drake has used the label's platform to promote tracks leveling similarly incendiary attacks on Lamar. That's their phrase, filed in black and white. Round 2, discovery, the legal version of crate digging. Except for looping a horn stab, you're scrolling through emails with subject lines like "circle back." Drake's team doesn't just want the lyrics judged in a vacuum. They want context, contracts, internal memos, who pitched what, who approved what, and who knew the record would become a stadium chant before it hit the stage. That's the strategy. Widen the frame until one song becomes the whole playbook. UMG fires back with a glove check. This is a defamation case, not a corporate tour. You don't get to turn discovery into a label exposure. They argue the standard is tight. Ask only for what proves the claim. No fishing expeditions, no scavenger hunts, no unlock all the vaults because vibes. It's the courtroom equivalent of telling a DJ only the record on the turntable counts. Then a twist, because show business can't resist the plot device. A sworn letter from the top floor lands on the docket. Calm tone, big stakes. Translation: the boss is speaking. The highlights hit like gongs. First, the company invested serious money in the artist. Second, the company bought and owns most of the recording catalog. That third line is the thunder. It reframes motive in one breath. If you own the bulk of the hits and the pen behind them, why torch the asset? It's a chessboard statement, delivered with that corporate poker face that says we prefer spreadsheets to slap fights. Back to the hearing. The judge keeps pressing the same pressure point, the ordinary listener test. Not the superfans decoding triple entendres, the mall walker, the gym regular, the aunt who only knows the hook. If that listener could hear a line as a specific factual claim, then we're not just in rap battle territory, we're in reputational risk. That's why legal folks use the phrase rhetorical hyperbole. It means the kind of exaggeration no one should take as literal, trash talk with tassels. Then the judge fires a curveball. What if the ordinary listener is a 13-year-old at a bar mitzvah hearing this for the first time? And note that the song has even turned up at some events. And when the judge points to Drake's tailor-made freestyle, talk about him liking him young, that's a gift for me, she asked if Drake wasn't daring Kendrick to go there in battle. That push and pull became a pivot in Rome. On the law, Drake's counsel says you can't isolate one line. The judge replies the tracks are a dialogue, but context at release matters, not months later after virality. That timing point will matter later. And that's the delicate tightrope here. In hip-hop, he's finished is theater. In court, he did X can be litigation. The judge runs the classic test: precision, verifiability, and the overall vibe. Was it a heat check in a musical performance, or is it stated like a report? The answer decides whether this case goes the distance or it gets stopped on cuts. Zoom out. The cultural weirdness is real. A diss track became a community soundtrack. You heard it crossing streets, at summer games, blasting from cars. When art leaks into everyday air, the legal risk surface widens. The ordinary listener isn't in the studio. They're in the line at the smoothie shop hearing the chorus for the 20th time. And the visuals matter. Cover art with red pens around an address, a video with choreography that doubles as a taunt. Those things are part of the message. Courts don't grade lyrics alone. They look at the package: song, art, rollout, performances, timing. Context is king. Sometimes the throne is a trending page. Quick note, I'm keeping the language as clean as possible. If a disputed lyric is central to the case, I'll show the verified quote on screen and keep it moving. For example, I hear you like them young. It's culturally unavoidable to reference, and it shows why the legal stakes are spicy. I won't linger, I'll just analyze. Drake's legal lane tries another angle: scale. They argue the song didn't just live online. It got megaphone boosts, halftime clips, award shows, citywide chants. Their point is simple: amplification multiplies harm. Drake's filings even float illegal promotional tactics allegations speculations around how the track blew up, a separate fight over how the message got so loud. If the line lands in front of millions who don't know rap theater from court testimony, the damage isn't niche, it's national. UMG's return. Art goes where culture takes it. No label memo can force a chant into the streets. If the crowd carries it, that's the crowd. And exaggeration is baked into the genre. Punchlines are punches, not police reports. Who's right? That's why discovery matters. Paper tells the truth tour posters can't. Who knew, who planned, who approved? That mosaic decides whether a jury hears this case or it ends at the judge's desk. Round 3 opens with the judge leaning in on the only question that matters. When a bar sounds like a headline, who hears it as proof? Not the superfans on Genius, formerly Rap Genius. Not the music lawyers counting syllables. She means the everyday listener. The person who catches the hook at a gas station and nods to the beat without clocking the metaphors. That listener decides whether a punchline lives as performance or lands as a claim. The judge also narrows the frame. Assess the meaning at release, not months later after billions of streams and a Super Bowl clip, like judging two people's street argument in the moment it happened. Cue the legal spotlight. Actual malice. Translation in plain English, if you're suing as a public figure, you don't just prove that hurt me, you prove they knew it was false or didn't care whether it was true and said it anyway. It's the highest rim in the gym. You need receipts, not vibes. Texts, emails, meetings, anything that shows someone looked at the stop sign and hit the gas. Now layer in the opinion versus fact test. Courts don't slice lyrics like poetry class. They ask 3 blunt questions.
1. Are the words precise enough to be verified? 2. Can they be proven true or false in the real world? 3. What's the overall vibe? Satire, battle talk, or a straight-faced report? If the answer leans, this is a roast, protection grows. If it leans, this is a report, liability walks into the room with a briefcase. UMG hammers a simple point. Random online comments aren't the test. Courts look to the objective, reasonable listener, not a handful of posts with jokes, emojis, or slurs. And they cite Rappaport versus Barstool Sports, where similar look at these comments evidence got tossed. The judge also focuses on how the message traveled, because scale can change how that test lands. A diss track that starts as inside baseball but turns into a crowd chant changes the stakes. Award shows, arenas, citywide DJ drops. Scale converts lyrics from boutique to billboard, and that's the exact friction point. Does popularity convert hyperbole into ordinary listener harm? Or is that just the cost of being famous during a cultural earthquake? Discovery is where those questions get oxygen. Expect a scavenger list that looks like a tour writer. ESI, electronically stored information from key custodians, A&R leads, product managers, marketing heads, chat logs, iMessage, WhatsApp, Slack, where modern decisions actually happen. Approval chains, who cleared the record, the visual rollouts, the stages where it was performed, audience mapping, media plans, playlist pitches, influencer seeding. If the paper trail shows careful staging designed to make a line read like a statement, Drake gets runway. If the trail shows a typical drop the record, watch it go cadence, UMG gets cover. And visuals? They're not decorations in court, they're exhibits. Single artwork, performance staging, social teasers, even crowd prompt graphics can tilt the judge's read on vibe. A winking visual gag screams theater. A grave graphic whispers, we meant it. When the court says context, it means the whole soup. Sound, image, rollout, timing. There's also the shadow of anti-SLAPP statutes, laws built to protect speech on matters of public interest, and in some states, to punish lawsuits meant to chill expression. Fee shifting, early dismissal, higher fault standards. Those tools sit in the wings. In federal court, the interplay can be messy, but the signal stays the same. If the case looks like a creativity chokehold, defense lawyers reach for the anti-SLAPP lever. Meanwhile, motive is the subtext playing bass in the back row. Corporate filings that say, in essence, we own most of the catalog and publishing take oxygen from the idea of self-destructing an asset. But respondents respond, ownership isn't immunity. If something crossed the line and caused reputational damage, the cap table doesn't erase the bruise. Let's talk proof lanes. For Drake to win, expect his side to chase 4 pillars. Specificity, flag lyrics or moments that can be read as precise, factual allegations. Falsity, show they're provably untrue in the real world. Fault, pull internal comms that show somebody knew or didn't care. Harm, tie the blast radius to real-world hits. Brand deals wobbling, bookings in limbo, safety issues escalating, costly PR triage. UMG will counterpunch with its 4. Hyperbole, frame the lines as tradition, battle speak, not bulletins. Context, package the music, visuals, and performances as theater. Amplification, not equal intent. Scale came from culture, not a memo. First Amendment weight, remind the court that jurors shouldn't become A&R leads. The judge's tightrope. Avoid turning courts into rap referees without letting viral megaphones launder harmful claims. If she lets the case proceed, it's because at least one line in full context could hit a layperson as an alleged fact. If she trims it, it'll be because the total vibe screams performance. Discovery day is where the soundtrack cuts and the spreadsheet speaks. First bell, motions to compel. Drake's team says, open the lockers, custodians list, date ranges, search terms, the whole e-discovery starter pack. They want the approvals, the chat logs, the are we sure about this threads that turn marketing into motive. UMG responds with a stiff jab. Narrow it, keep it proportional. No fishing in the Mariana Trench because you saw a fin. Concrete cuts the fog. Drake wanted Interscope CEO John Janik's pay and bonus records back to 2021 and 2024 executive bonus metrics. UMG says that's irrelevant to one 2024 song and video. Drake sought 5.5 years of Interscope monthly revenues and profits and Kendrick's catalog valuations. UMG says you can't tease out one track's effect from everything else. On Kendrick's contract, UMG produced approval and edit rights plus headings, kept sensitive business terms redacted, offering in-camera review by the judge.
Second bell, motions to quash. That's the defense telling the court some of these subpoenas are trying to turn the diss into a documentary. They argue the complaint is about specific lines, not a decade of label philosophy. If it doesn't tie to the allegedly harmful statements, it's out. In between, the most underrated scene in any lawsuit, the meet and confirm. Imagine two teams huddled over a Google Doc that looks like a grocery list for a stadium tour. 1. Custodians, product managers, A&R leads, marketing leads, tour and TV coordinators. 2. Date windows, pre-release hype, release week, the first wave of virality, major live moments. 3. Search strings, song title variants, project code names, shorthand nicknames, stage cues. 4. File types, emails, chats, decks, run-of-show PDFs, asset notes, stage direction drafts. Now the guardrails, protective order with confidentiality tiers like confidential or attorneys-only eyes, clawback terms for accidental disclosure, ESI protocol for how to collect, dedupe, and produce without turning hard drives into confetti. And yes, the judge can order a sampling run, produce a slice, see if it's actually useful, then decide whether to widen the hose. Why it matters? If the documents read like theater, lean into the spectacle, this is performance, let the crowd do the rest, that helps the defense. If they read like a bulletin, state X, driving home, amplify the allegation, get it on the biggest stage, that boosts the plaintiff. Paper don't roll in size, paper tell you what the room believed. Meanwhile, the evidence lanes are forming like lanes on the highway. First, lyrics and packaging, artwork, captions, stage prompts equals the message. Second, placements and performances, award shows, televised moments, stadium cues equals the reach. Third, internal intent, emails, chats, rehearsal notes equals the mindset. Fourth, after effects, brand calls, venue requests, security spend equals the impact. Remember the judge's refrain, the ordinary listener, not the lyric nerd, the casual ear. Courts weigh 3 dials, precision, verifiability, and vibe. A flex in the cipher, leaning opinion. A statement framed like a fact, leaning liability. That's why packaging is evidence. A wink on the thumbnail, theater. A sterile, read this graphic, statement energy. Back in, the timeline is the hidden boss fight. Who knew the track would go nuclear and when? If scale was inevitable by design, big shows, coordinated choreography, audience prompts, the plaintiff says that multiplies harm. The defense says culture is not a memo. In law speak, amplification does not equal intent. Then there's the ceiling called actual malice, the public figure bar that asks, did you know it was false or speak with reckless disregard? That's why discovery reaches for the receipts. We checked, we didn't check, or we didn't care. The answer is the difference between a tough day and a trial date. Even if a lyric is wobbly, judges are reluctant to yank art off the map before a jury sees it. Structure of a remedy matters. Narrow fixes beat broad muzzles. Money beats muzzle 9 times out of 10. You'll also hear the defense tap the anti-SLAPP drum, those speech protective statutes that let judges boot flimsy claims early and sometimes shift fees. It's not a magic spell, but it's a pressure level. If this is trying to chill expression, the law gives us a shield. Now the corporate elephant that stomped into the room, the top floor letter confirming major ownership stakes in the artist's recordings and publishing. That is not a punchline, it's a ledger. The defense reads it as motive to protect the asset, not scorch it. The plaintiff replies, ownership doesn't grant a hall pass. If the message crossed the line and caused reputational injury, cap tables don't cure bruises. The court's balancing act is brutal, but clear. Don't turn judges into A&R leads. Don't deputize stadium chants as sworn affidavits. And don't let a viral megaphone watch harmful claims in the name of, it's just art. That's the new American genre, First Amendment versus First Impression. The next bell is procedural, but don't let the tie fool you. This is where fights are won on points.
Rule 12 trim. Think of it like a referee's pre-fight check. The court skims the complaint with a sharp pair of scissors and asks which claims are legally strong enough to stay on the card. Anything that reads like, "you hurt my feelings" without a legally verifiable statement gets cut. Anything pled with particularity, who, what, when, where, how, survives to swing. This matters because jury trials aren't marathons. They're curated playlists. Only the tracks that meet the legal key signature make the album.
Targeted discovery. Once the scissors finish, the clock starts. Narrow custodians, tight date windows, search terms that don't pull in a million LOLs. The judge might order phased production. First the core decision makers, then a sampling of marketing decks, then a small slice of showrun documents. If those samples show signal, actual decisions tied to the messaging, the faucet opens wider. If not, the hose kinks shut. Then there's the live event wildcard. The Exhibit A is the studio version. The televised performance with crowd prompts, overhead graphics, and camera crane swoops is Exhibit Wild. Courts don't grade vibes, but they do grade context. If staging choices nudge an audience to read a line as a straight claim, the legal temperature goes up. If staging winks, choreography is satire, cheeky lower thirds, playful cutaways, the temperature cools. Depositions are coming, the unsung thriller arc. Back to the chessboard. Expect experts. Yes, hip-hop culture professors and communications analysts. One lane explains battle rap norms, exaggeration, coded language, the difference between a character and a claim. Another lane does audience analytics, who heard it, how often, in what settings, and whether the average person would treat it like a news bulletin or a stadium chant. A third lane models reputation impact, linking exposure to measurable consequences, brand pauses, venue hesitations, security costs, crisis PR spend. Speaking of costs, the damages conversation splits in two: general, non-economic, the hard-to-measure dents, reputation hits, goodwill erosion, the smoke that lingers in the public square, special, economic, line items with decimals, canceled obligations, renegotiated rates, additional protection measures, publicist overtime. Courts prefer receipts to vibes. The cleaner the spreadsheet, the clearer the story. Now the PR shadow trial, two narratives running in parallel. One storyline, art must be free to jab, feint, and posture. The culture breathes through friction. The other, even art has guardrails when a line starts wearing the suit of a factual allegation. Both are true in America's legal songbook. The question is which one conducts this orchestra. And then, calendar gravity. Hearings bunch up. A scheduling order drops like a tour poster. Amended pleadings by this date. Substantial completion of discovery by that date. Expert reports marching in formation. Summary judgment motions queued like an encore. Everyone pretends this is calm. No one is calm. The summary judgment round is the pre-trial boss. Defense says, even taking the facts in the best light for the plaintiff, the law says we win. Hyperbole, context, First Amendment weight. Plaintiff says, not so fast. These statements are precise, verifiable, and were pushed with knowledge or disregard. A jury must decide. The judge wheels the scales. If she sees disputes a jury must sort, the case moves to the big room. If she sees law that swallows the quarrel, the curtain falls early. Last beat for this round, the ordinary listener remains the invisible jury number 13. Every motion, every exhibit, every clip is aimed at that person's ear. If they're likely to hear theater, defense advantage. If they're likely to hear a claim, plaintiff advantage. It's that simple and that impossible. Depositions don't bring fireworks, they bring pressure, long tables, stack of exhibits, a blinking red light that makes even extroverts talk like librarians. This is where timelines harden and vibes die. Who approved this? When did you know that? Show us the doc. Every answer either shores up this was theater or feeds this sounded like a claim. The cast list looks like a tour laminate. A&R lead, product manager, creative director, live show producer, social strategist, and any executive whose calendar was a game of Tetris the week the single dropped. Counsel walks them through the roadmap, pre-release brainstorming, clearance checklists, rollout decks, slotting on big stages, and how crowd prompts are chosen. A clean record shows ordinary showcraft. A messy record suggests message engineering. Then come the exhibits, the mixtape of corporate life, email threads, Slack snippets, production rundowns, call sheets, ad plans, influencer briefs, show notes. Each one gets a small blue sticker and a big meaning. Taken together, they tell the only story a jury trusts, the paper one. Meanwhile, both sides sharpen trial themes like they're cutting trailers. Plaintiff's trailer. This wasn't trash talk. It was presented like a statement, scaled on the biggest platforms and framed so a casual ear could mistake it for a fact. Popularity didn't happen in a vacuum. It was choreographed. Result, reputational harm you can count, plus all the smoke you can't. Defense's trailer. Welcome to performance art. The track sits inside a battle tradition built on swagger and exaggeration. The packaging signal theater. The crowd, not a memo, supercharged the chant. In America, we protect art, even when it's loud. Jury selection becomes its own mini-series. You don't need experts in rhyme schemes. You need jurors who can tell the difference between a roast and a report. Anyone who treats every lyric like a press release? Risky. Anyone who thinks music is never serious? Also risky. The sweet spot is people who can live in nuance without needing a dictionary every 8 bars. Those dials will matter at trial. Precision, verifiability, and vibe. Then come the witness lanes. Culture experts explaining diss track norms, character versus claim, metaphor, and why chest thumping is the currency of the form. Communications experts mapping how casual ears hear hooks out in the wild. Live show producers unpacking staging decisions, graphics, camera cues, chant prompts, security, and brand reps linking scale to consequence, increased protection costs, paused projects, renegotiations, risk memos. The evidence choreography matters. Timelines on big boards, side-by-side clips, studio audio versus arena broadcast, thumbnails of rollout assets with captions. In court, patience wins. You assemble understanding like Lego bricks. No single brick does it, the build does. Hovering over everything is the tallest rim in the gym, actual malice. For public figures, the law asks whether speakers knew something was false or ran with reckless disregard for the truth. That's why texts and approvals loom large. Checked, not checked, didn't care. Juries hear those 3 answers very differently. And then, remedies reality. Courts are allergic to prior restraint, fancy term for gag orders on speech. Even if a lyric is dicey, judges are cautious about muzzling art before a jury speaks. Money damages? Possible. A narrowly tailored statement? Maybe. But pulling a hit off the planet? That's a fire alarm the First Amendment rarely lets you pull. On a parallel track, summary judgment creeps closer. Defense will say, even if you read every fact in the other side's favor, the law still shields this as opinion and performance. Plaintiff will counter. These statements, in this packaging, read as provable claims to an ordinary ear. A jury must decide. If the judge sees genuine disputes about how a casual listener would hear it, the case goes to the big room. If she sees a wall of hyperbole in context, lights out early. Returning to scale. Does getting louder change legal meaning? The plaintiff frames scale as a multiplier of harm. The defense reframes scale as democracy at work, crowds choosing a course. The judge's job isn't to love the art, it's to ask what the ordinary listener reasonably took from it. Next, the filings heat up with clipped deposition excerpts. The court rules on what the jury can and can't see, and both sides test drive their closers. Tight 5-minute versions of their thesis that try to live rent-free in jurors' heads all the way to the verdict. Pre-trial is where quiet decisions change loud outcomes. Motions in limine, the legal version of don't play that record for the jury. Each side tries to mute anything too inflammatory or too confusing. Plaintiffs asked to exclude flashy montages that turn the courtroom into a concert. Defense asked to exclude headlines and hot takes that treat lyrics like sworn declarations. The judge reaches for the Rule 403 fader. If it confuses more than it clarifies, volume down. Then, authentication. Rule 901. Every clip, post, and graphic has to prove it's real. Screenshots need metadata. Social uploads need the chain to the original. It was trending doesn't prove it's authentic. That's why paralegals become Indiana Jones with hard drives. Next lane, hearsay. Not every statement gets on stage. The rule's simple in spirit, messy in practice. If you're offering a statement for the truth of what it says, it's usually out, unless it fits an exception. Business records? Maybe in. Party opponent? Often in. Random blog? Usually out. Cue the evidentiary volleyball. Now, the jury instructions draft. Dry pages, big consequences. Expect these dials to appear in plain English. Opinion versus fact. You must decide whether an ordinary person would hear a line as opinion, hyperbole, or a factual claim. Actual malice. Because the plaintiff is famous, they must prove the speaker knew a statement was false or seriously doubted it and said it anyway. Context. Consider the packaging, music, visuals, performances, and how the audience encountered the message. Those instructions become the map jurors carry into deliberations. Precise maps win trials.
Quick glove touch with the algorithm before we push deeper. Tap like, smash subscribe, ring that bell. It's free, it's fast, and it keeps this showdown center ring instead of hidden under the bleachers. Back to the war room. Both sides build storyboards like film editors. Plaintiff storyboard highlights. Side by side. Quiet studio track versus mega stage presentation. timeline overlays, internal planning versus public rollout, brand and safety memos, how phones rang after key moments, defense storyboard highlights, battle rap lineage reels showing satire and swagger as the norm, packaging breakdowns that wink at performance, art choices, staging, crowd prompts, charts showing culture-led virality, organic spikes, not memo-driven pushes. And then comes the most human piece, voir dire, picking the 12. Lawyers look for balance beams, people who can hold two truths. Art gets rowdy, and words carry weight. Folks who don't faint at rhymes but also don't treat hooks like press conferences. Too credulous? Out. Too cynical? Out. The middle lane is gold. Openings are theater with receipts. Each side promises a story the evidence will keep. Plaintiffs speak in verbs. Approved, planned, presented. Defense speaks in nouns. Tradition, performance, hyperbole. If an opening makes jurors nod in unison, that team just won the coin toss. Witness order is strategy. You'll likely see a culture scholar early to give jurors the toolbox. Metaphor, persona, roast versus report. A communications expert to map how casual ears hear hooks out in the wild. An executive or product lead to walk the approvals step by step. A live show producer to explain how staging signals playfulness or seriousness. Someone on risk, brand, or security to tie scale to line items, extra precautions, pause deals, shifting schedules. Side note on language safety in the script, we keep phrasing neutral and advertiser-friendly. When reference to a sharper line is inevitable, we quote short, then move on. Context beats shock every time. Now the chess clock. Summary judgment is argued, maybe trimmed, maybe denied. If it's denied across the board, the message to both sides is simple. A jury will choose the story they believe. That's when phone calls start about a word the public never hears, but every litigator respects. Settlement. What would a settlement look like in a case like this? Think no admissions, narrow statements of principle, and forward-looking guardrails. Language about respecting art while being mindful of how messages scale. Maybe even a joint note to the culture, crafted at a level that keeps the First Amendment smiling and the spreadsheets calm. But if the calls don't land, the doors open and the trial begins. The first big reveal, how each side plays the scale question. Does volume turn showmanship into statement, or does a chant stay a chant even when the whole city joins? Openings land like the first punch after the stare down. Plaintiff stance.
You'll see how this wasn't just swagger. It was framed, scaled, and presented in ways an everyday ear could mistake for a statement. And when the volume went up, the damage did too. Verbs everywhere. Approved, presented, amplified. Defense rises. You'll see a living tradition, performance, persona, competitive exaggeration. The audience knows the difference between a roast and a report. The packaging told them so. Nouns like shields, context, hyperbole, art. Then comes the quiet star of every courtroom, the screen. Clip 1, studio audio. Clip 2, live broadcast with crowd prompts. Clip 3, cut down snippets that went viral without captions. The same line feels different in 3 habitats. That's the point of the day. First witness, culture expert. They translate the genre without killing the magic. Persona is explained, how an artist can wear a character like a costume. The chorus as a chant, not a chapter heading. The jury nods. Language gets unknotted. Cross-examination. Tight questions to wedge opinion from claim. Is there ever a moment in this tradition where words cross a line? The expert refuses absolutes. Context is oxygen. Counsel tries again. The judge keeps the pace brisk. Second witness, communications analyst. They bring graphs, frequency, reach, setting, grocery stores, gyms, party playlists, televised moments. Ordinary listener isn't a metaphor anymore, it's a demographic curve. The point is not shock, it's scale. Cross. Isn't virality often organic? Answer, yes, but presentation affects how quickly inside becomes outside. 2 truths holding hands. Third witness, live show producer. A run sheet appears, lighting cues, camera lanes, choreography notes. The producer explains how staging can wink or stare, how a lower third or a backdrop either plays along or plays it straight. The jury leans in. Production is rarely this visible. Cross works the seam. Did crowds improvise right? You can plan a moment, but you can't script the city. True, the witness says. You can place a spark, not the wind. Fourth witness, brand and safety operations. This is where numbers enter. Extra shifts, reroutes, meeting memos with bullet points under the word risk. No melodrama, just line items. Jurors don't love adjectives, they love receipts. Cross stresses causation. Are you saying this caused that decision or that it coincided? The answer is careful. We assess clusters of signals. This was a large one. The courtroom exhales. Nuance wins around. Defense begins its case with lineage. A curated reel traces playful exaggeration from battle tape basements to arena catwalks. The message? This tone has elders. It didn't materialize to target one person. It lives here. Next, creative director. Mood boards. Style notes.
the intentional humor in a prop or a cutaway, laughter that the microphones didn't pick up in the stream but roared in the room. The frame says play, that matters. Cross snips at intent. You understood the line could be taken literally by someone outside the culture, yes? The answer returns to the same anchor. The total package signaled performance. A procedural skirmish pops mid-trial. Sidebar. The judge rules a flashy montage too prejudicial. Trim the music. Keep the sequence. Lawyers dislike it. Jurors appreciate the clarity. Rule 403 hums like a fridge. Then a small bomb. A chat excerpt appears in evidence with a joking tone that reads flatter on paper than it sounded among colleagues. Plaintiff points to it as planning. Defense calls it sarcasm. Messages age badly without voice notes. The jury stares at punctuation like it's a confession. Closing arguments start to gather in the hallways. You can feel them being sharpened. Plaintiff's spine. Precision exists. A casual ear could hear a claim. Scale wasn't an accident. Harm didn't need headlines to be real. The invoices say enough. Defense's spine. The whole context screams performance. No one treated these lines like court filings. Not the creators, not the core fans. Culture scaled it. Corporations chased it. The Constitution protects roar, not just recital. Judges' instructions land like sheet music. Opinion versus fact. Actual malice and context. Plain English, straight rails. The jury files out with a binder and 12 different heart rates. Deliberations blur into clock ticks. Jurors test sentences out loud. What will my cousin hear at a cookout? Does a chant feel like a claim? How much do staging and graphics tilt meaning? They mark exhibits, circle timestamps, and argue politely about what ordinary means in a culture that's anything but. Here's the truth. Whatever verdict emerges, the precedent is the bigger echo. If jurors say a chant can be heard as a claim, disc records everywhere get a new dress code. Precision becomes risk. Rollout decks earn a legal read-through. Staging meetings start with the question, could this land as a statement for someone who's just vibing? If jurors say opinion in theater, the genre gets a larger shield, and the conversation shifts to ethics and taste rather than liability and damages. Zoom out to the industry ripple. Writers' rooms will begin labeling lines by risk tier, color-coding bars the way stunt teams color-code fight beats. Live show producers will add a vibe check to run of show, what signals play versus what signals pronouncement. Marketing teams will weigh amplification paths, organic fan energy versus institutional megaphones. Lawyers will live earlier in the process, not as bouncers at the door, but as choreographers of safe spectacle. And in the middle of it all, the ordinary listener becomes the quiet star of modern music law. The cousin at the cookout, the gym member with earbuds, the car next to you at the red light. Courts will keep asking, what does that person likely hear? Small joke to loosen the shoulders while we wait. Courtrooms and studios do share one thing. Nobody admits the air is cold, but everyone's freezing. Back in the gallery, the clerk reappears. Not with a verdict, yet, but with logistics. If the jury doesn't land today, they'll resume tomorrow. The soundtrack of patience plays, footsteps, whisper hums, the soft click of pens. Regardless of outcome, one lesson is already stamped. Scale is not just volume, it's meaning. A bar in a booth is a barb. The same bar on a blinding stage can feel like a bulletin. The fastest way to stay honest, artist or exec, is to treat context like a co-writer. If the room signals play, your odds of protection rise. If the room signals report, your risk climbs stairs 2 at a time. This isn't just a case about one song or 2 stars. It's the blueprint battle for how music talks to the world. If a chant can be a claim, the stage changes forever. If a roast stays a roast, even at stadium volume, artists keep sharper elbows and wider lanes. Next episode, we're cracking open the contract vault, the new economics of catalog control, why ownership letters, distribution webs, and publishing chess moves can swing a courtroom narrative before a single bar is written. We'll map the money, decode the paperwork, and show how one clause can decide whether your biggest hit is a shield or a boomerang. Until then, protect your pen, respect the stage, and keep your context loud and clear. Type like, smash subscribe, drop your take below, and as always, champions, I'll see you ringside for the next round.